sección nos centraremos en las actuaciones de la Comisión en la actualidad y cuáles son los retos que las agencias de competencia estamos enfrentando en el presente. Para abrir conversación, escucharemos la ponencia titulada Mejores prácticas internacionales en la aplicación de la política de competencia a cargo de Ioana Marinescu, economista principal de la División de Antitrust del Departamento de Justicia de Estados Unidos. Ioana Marinescu es doctora en Economía por la London School of Economics and Political Science y por la Escuela de Estudios Superiores de Ciencias Sociales de París. Además es máster en Econometría y Filosofía por París I Panteón Sorbonne. Fue profesora asociada en la Escuela de Política y Práctica Social de la Universidad de Pensilvania y desde julio de 2022 es la economista principal de la División Antimonopolio del Departamento de Justicia de Estados Unidos. Bienvenida.
Well, I'm really glad to be here. Thanks so much for inviting me. So today I'll be talking to you about some of our recent policy at the Department of Justice Antitrust Division. And specifically, I'll be focusing on an area where a lot of my academic work has been focusing, which is the area of labor and antitrust enforcement. This is an article from The Economist from 2018. Economists think antitrust policy should pay more attention to workers, and this was partially reporting on some of my academic work that I did at the time. And just to give you a little bit of history, so eventually, as was said, about a year ago, I joined the Department of Justice on leave from my appointment as a professor at Penn in economics, and it's been really amazing. And in my job as a principal economist, I oversee the economic analysis of all of our cases across the division. So while today I'm focusing on labor because this is one of the big, interesting, things that we're looking into, my portfolio includes all of the cases that go through, and so that's important context to understand here. So. There is a history of this within also, so I was showing you an article from the press, from The Economist, and I told you that there's been growing academic work in this area, but there's also been policy attention. So in 2021, President Biden had an executive order on promoting competition in the American economy. So it was all about competition, and one of the things that was recommended is to review the horizontal and vertical merger guidelines, and to consider whether to revise those guidelines. As I will tell you later, we now did that, and we have a draft new merger guidelines, and I'll tell you a little bit about what's in there. And then they also commissioned a report on the state of labor market competition, and that came out in March 2022. And finally, and I think this is a topic of great interest to antitrust enforcement around the world, there is a new and renewed emphasis on collaboration, what they call the whole of government approach to competition cooperation across government agencies within the existing statutory mandates, but simply seizing the opportunities that we have to collaborate across agencies to promote competition in a variety of areas across the US economy. So let me first talk to you a little bit about the theory and the empirical evidence around competition in labor markets. So if you're familiar with the usual antitrust framework for product markets, I've shown you that on the left-hand side. We have sellers and consumers. Consumers choose to buy from sellers if they have a choice, if it's not a complete monopoly. And then the sellers may exercise monopoly power over the consumers. In the case of the labor market, you can think of employers as buyers of labor or labor services. And then the workers choose which employers they're selling their services to, and the employers may exercise, we call monopsony power, over the workers. So that's the analog situation for sellers versus buyers. I will add that, of course, this situation with buyers and sellers is not unique to only labor. There are other markets, input markets in general in the economy, where you could think about how sellers might exercise monopsony power over other input sellers. So labor is one input, but you might have many others. And some of those cases, for example, that we are looking at include agricultural markets where farmers sell, their product to various enterprises, and you could have similar monopsony issues that occur in those markets, among others. So, okay, so, sorry, I jumped a slide. There we go. So economic theory, so essentially there's a key lesson here, which is the parallel between product market competition and labor market competition. So we know that product market concentration, or in the extreme monopoly, is going to increase prices for consumers in the product market. The analogous phenomenon in the labor market is that labor market concentration, or concentration of employers, is allowing for monopsony power and is going to decrease wages for workers. So that's the parallel phenomenon in the labor market. And now let me walk you through some intuition about how economic models of imperfect competition in the labor market work. So the most widely used one is the monopsony, the classic monopsony model. So in this imperfect competition market, you have wages that are below marginal productivity. So if you have perfect competition, workers are fully rewarded for their productivity. If you don't have perfect competition, that's not the case. There is a gap between what workers are earning and their productivity. And so in the basic monopsony theory, there is an assumption that the firm has to pay all workers the same. So when a firm that has market power is seeking to hire an additional worker, so remember, when we have a perfectly competitive market, there is the law of one price or one wage, and there is no debate about what should I pay. There is the wage. If I don't pay enough, I'm not going to hire anybody. But when a firm has market power, I might consider increasing my wage to attract more workers. However, as I'm thinking of hiring that very one last worker, now if I hire you for a higher wage than the incumbents, I need to raise all incumbents' wages up to the wage of the new hire. And that means that as a firm, I'm considering that in my decision, and I might decide at some point not to hire more because I don't feel like increasing everybody else's wage. And this phenomenon means that firms are going to stop below the optimal level of hiring that you would have, in a competitive market. And so as a result, the firm is going to find it more profitable to hire fewer workers, I mean fewer than under perfect competition, and pay them less than under perfect competition. However, they're making higher profit on every worker, right? So that's the idea, and it's exactly, if you think about it, like a monopolist acts in the product market. It would have her sell to fewer customers, but charge them a higher price, make more profit on those customers. So here it's reverse. Instead of charging high prices, we are paying low wages, but in the end, the result is the same in terms of making a profit on that worker. And so, therefore, also under standard economic theory, monopoly and monopsony reduce output through the same basic mechanism. So under monopoly, it's a well-known phenomenon that they decide on lower production levels. Here, they decide to hire fewer workers. But in a simple model where workers are the only input in production, that immediately translates to lower output. If you hire fewer workers, you're also producing less. So therefore, monopsony reduces output in the basic monopsony model. All right, so here's some quick overview of some empirical evidence in the literature. So this is from one of my papers with Jose Azar and other co-authors. We show that 60% of US labor markets are highly concentrated. So on this map, there are the red and orange markets. And this is correlated with population density. If you're a bit familiar with the US, you will know that in the middle of the country, it's less densely populated, there's mountains, and so there is a correlation between the degree of concentration in labor markets and population density. And if you think about it, it kind of makes sense, because in cities, there's usually a lot of different employers, and less so, in less densely populated areas. Secondly, we also find that higher labor market concentration is associated with lower wages. So the more concentrated the labor market, and even if you look within a labor market, as the concentration in a market increases, wages tend to decrease. So that's the pattern you see in the data. People have also looked at mergers specifically in other papers and have shown that when a merger leads to a great increase in labor market concentration, it also decreases wages. So it's all consistent with the idea of concentration depressing wages. This is a list of additional evidence, including on mergers, but I don't want to go through all these details. The one thing I want to point out for this audience here is that there is a very recent hot off the press working paper about Mexico. So at the very bottom, the IADB has a new paper on Mexico by Kazufi and co-authors, and they showed that in Mexico, as well as in the US, like I've just shown you, higher concentration is associated with lower wages for Mexican workers. All right, so this was a brief overview of what do we know from economic theory and academic evidence from economics. Now let's move into enforcement. And I'm going to start with labor markets and merger review. So in the US legal framework, how would you look at this? How do you look at this? So since 1982, the merger guidelines, so remember the merger guidelines in the US are a document that says the intended policy of the antitrust agencies. These are the kinds of mergers that we will go after, and it spells out what is an anti-competitive merger. So since 1982, so as you can see, it's been a while, merger guidelines have always said that mergers of buyers can be problematic. Just I was showing you that diagram, right, of buyers exercising monopsony power. So this is an old thing that's been there since 1982 as a general matter for buyers. It didn't explicitly mention workers, but it just said the power of buyers over sellers can be problematic. And so then, you can then apply this to the labor market by noting that employers are buyers of labor service, so they fall under the buyer category. Then in the 2010 merger guidelines, which were the last ones before our new draft merger guidelines, they have a whole section that's much more developed on buyer power. And that explains, how you analyze the power of buyers, but again, without explicitly applying it to labor markets. And I'll talk in a second about what we've done in the draft merger guidelines. And so then, with that in place, you can look at a horizontal merger. So that means a merger that involves competing employers. They may not compete potentially in the product market, potentially. So, you could think, for example, of a merger of two companies that have huge accounting departments, but that work in different industries. And therefore, they might be competing for the labor services of accountants. And depending on specifics, it could be the case that this significantly decreases competition for accountants, even though hypothetically, perhaps there isn't a problem in the product market. So therefore, you have to look at competition for labor services. And so horizontal mergers that are potentially anti-competitive would lower wages or lower wage growth, either because of a reduction in competition among the buyers of labor, or because of potentially collusion, increased risk of collusion among the buyers of labor. And we'll talk in a moment about our cases in employer collusion. And so importantly, because of this setup, all of the tools that we have from the horizontal merger guidelines apply to labor markets just as well once you interpret them to be markets where labor services are bought and sold. So then, reminder, therefore, it's a direct parallel between the product market kind of analysis that you do on the left and the labor market analysis on the right. But you have to be careful because sometimes we're so used to product markets that we might kind of invert certain things, so you have to kind of get it straight, but ultimately it's exactly parallel. So here's one merger where we used monopsony theory before, so this is all before the new draft merger guidelines, so under the old regime, and the Department of Justice won this case. So let me tell you just very briefly about what this case was all about. This was a merger of publishers, of two very large publishers that was proposed, and the two publishers were Penguin Random House and Simon & Schuster. And so these were two of the largest publishers of books in the US. And so our argument was that the merger would have decreased the competition between publishers to buy, so it's a buy-side case, to buy the rights to publish authors' books. And therefore, the merger would have harmed authors in terms of getting lower prices for their work in the form of books that they have to sell to the publishers. And so there was a decision by US District Court Judge Florence Penn in October 2022, and it had some very, in the US precedent is really important, it had some very interesting, holdings in this judgment. So I wanted to cite some of it here. So, and the parties, by the way, they chose not to appeal, so the merger was abandoned through and through. So, although most antitrust law has developed under the sell-side theory of harm, monopoly and monopsony analysis relies on similar principles, which is what I just explained. And then she adds, under the government monopsony theory, the authors of anticipating top-selling books are targeted sellers against whom the merged defendants might lower the prices paid for the author's work. So here, just to decode, anticipated top-selling books were books where the advance that the publishers would pay was going to be more than $200,000. And the reason why we focus on these books is because for big books, there really only are a few large publishers who traditionally enter this market at all to try to sell really big books. There's, of course, a huge tail, if you want to publish a small book, there's more choices. But for the authors who are in this market of selling top books, these are the options. There are very few. And this we argued, would have significantly reduced competition for these, again, anticipated top-selling books. So that's an example, and it's arguably the first time that the DOJ prevailed on a monopsony theory of harm and won a case in front of the judge. Now, we have a new draft merger guidelines from 2023, and comments are still open. So if you feel very inspired, we're still taking comments. So please, feel free to put in any comment. In this new draft merger guidelines, in general, we say that mergers can decrease the competition for labor, as I said, and also increase the risk of employer collusion. And, let me just make a few points. First of all, why did we add the labor? First of all, it's an obvious application of what was there before, but we wanted to clarify that it applies to the labor market and reflect some of this new research I told you about in economics that makes it very clear that market power is alive and well in labor markets. And that we also note that some labor markets are especially narrow because of high switching costs. It's, you can buy a different beer, but switching jobs, it can be quite costly for workers, as well as search frictions, that the process of looking for a job can be quite involved. So therefore, the labor markets may be quite narrow in terms of what are reasonable substitutes in the eyes of workers. We also clarified that agencies are going to evaluate the impact of mergers on labor as a standalone basis to challenge a transaction. That's what I was telling you before. We don't need to have a problem in the output market to challenge it. It's enough that there's a problem in the labor market. We will take action if a problem in the labor market is foreseen. And we also further acknowledge that the agencies are not going to allow downstream benefits to justify upstream harm. So in other terms, sometimes firms may argue, yes, we're going to pay workers less, but it will decrease prices for consumers. First of all, let me note that in the basic theory I was telling you about, this usually won't work. The reason is that under monopsony theory, remember, as we lower wages, we hire fewer workers, output goes down. So, prices ordinarily are going to go up, not down. But in any case, no matter what the case may be, we say that if there's clear anticipated harm in the labor market, we're not going to go and compare that with hypothetical benefits to consumers, because by US antitrust law, harm in any market, in any relevant antitrust market is enough. So, we look at a market, a labor market is a market like any other, and we're going to consider the harm in that particular market. But besides this, in general, the same set of economic tools to look at competition in labor markets can be used that were already there in the 2010 horizontal merger guidelines. So this, for example, includes things like diversion analysis, where now we're going to ask ourselves about workers switching from this employer to that employer, how often that happens. For example, that would be a tool to determine the extent of labor markets as an example. So, all right, so that was for mergers. So we have this development within our merger guidelines. Now, I want to talk to you about antitrust violations that are not mergers or conduct cases. So some non-mergers violations, they fall under criminal enforcement in the US, but might fall under civil enforcement in other countries, depending on what might be the case. And my understanding, I talk to people around here, so I'm no expert on Mexico, but it sounds like the same type of things can also fall under criminal in Mexico. But certainly in the US antitrust law, criminal cases are for price fixing and bid rigging, and for market allocation. And so for the labor market, how do you translate that? Well, price fixing is wage fixing. So when employers agree, this is how much we pay people, that's price fixing. Wage fixing specifically, but price fixing in general. And in terms of market allocation, an example of that in the labor market are so-called no poaching agreements. And as I will describe in a moment, the department has gone after those agreements. What they are is if I and an employer agree that we're not going to hire each other's workers. So that amounts to market allocation, because it's saying those workers are yours, my workers are mine, don't go compete for my people. Right, so it's a form of market allocation when we agree with each other not to hire each other's employees. So that's a no poaching agreement. So generally, if there are no additional reasons and details and whatnot, these acts therefore are so-called per se illegal in the US, and they're a felony under the Sherman Act. So it's a criminal offense. So. Here's an example of a recent success that we've had in a criminal case in the US. So recently, this healthcare company called VDA pled guilty in a conspiracy where they did two things. They fixed the wages of nurses, and they also restricted the mobility, making sure that they don't go to competitors. And so specifically this VDA company that at the time of the facts was known as Advantage on Call was one of two primary providers of contract nurses services. So these were a market where essentially there were only two options for contract nurses, and they agreed with each other to fix wages so these were actually school nurses, to fix the wages of school nurses. And so according to the plea agreement, it entered into with the government, VDA participated again in this conspiracy with another contract healthcare staffing to suppress and eliminate competition by agreeing to allocate nurses and to fix the wages. So they did both. And they were sentenced to pay a criminal fine of $62,000 and restitution of $72,000 to these victim nurses. And the fines here were based on a 20% volume of commerce calculation. And this case is important because it's the division's first successful enforcement in a no-poach case. I also want to talk to you about a decision by the US Appellate Court concerning no-poaching agreements. And so in this case, I don't know about Mexico, but in the US, it turns out there's been a number of academic studies looking at franchise agreements. So many chains operate as franchise operations, and it turns out in a number of franchise agreements, they had no poaching agreements, where they said that between franchisees and or between the mothership, you couldn't hire each other's employees. And so specifically at McDonald's franchises, there was a case where Deslandes is the plaintiff. She wanted to move to get a higher wage at a different McDonald's, and she was told that she couldn't, and found out that this was because of this no poaching agreement. So the argument in the first instance was that these franchise agreements violated Section 1 of the Sherman Act by reducing competition for fast food workers, that competitors agreed to this, and therefore this was an antitrust offense. However, they lost in the district courts. The judge didn't side with them, and we, at the Antitrust Division, together with the FTC, we filed an amicus brief on the side of the plaintiff to support their case when they went to the appeal. And so just recently, the Seventh Circuit, the appeal court, said that actually the district court was wrong by holding that the plaintiffs failed to state a per se claim. In other terms, they didn't think that throwing out this case was legitimate because the judge said this wasn't a correct claim that they made, and they just threw out the case. And so specifically in the opinion, which is for people who are interested in this issue, it's a very nice opinion to read. I'm no lawyer, but it's like a 3-page opinion. It's very nicely written. It's very interesting. They say that no poach clauses are horizontal agreements between competitors in the labor market, and if established, they could be per se illegal. So therefore, that's an important holding by the Court of Appeal. And it also said that the district court erred by allowing so the franchises says, oh, but we have to put these agreements because it's helping growing our business, which benefits consumers. And the judges in the appeals court noted that the district court erred by allowing potential consumer benefits to justify the detriments to workers. And they note, and here I quote, the antitrust laws prohibit monopolies just as they prohibit monopolies. And it's not an excuse to say, but it has these other benefits. And finally, the court affirmed that defendants bear the burden of showing that the no poach clauses, don't run counter to the antitrust law. So that's up to the defendants to prove. This is not on the plaintiff to show that. All right, so this concludes my section on enforcement on conduct cases, both criminal and civil. So now I want to tell you a little bit about our antitrust policy that is not just casework, but more on the policy side. So we have two dimensions to this. First, inside the Department of Justice, we have taken a number of actions. First of all, because labor market analysis is somewhat new for the Antitrust Division, as I said, sometimes you have to go through the motions and you might get a little confused which one's the buyer, the seller, etc. It's nice to have those guiding documents. So we have internal documents that allow DOJ staff to think about those cases and also think about the kinds of documents that you would need in a labor case in order to establish the usual things that we seek to establish. So for example, I was telling you earlier about diversion ratios. So in the case of the labor market, we want to know, for example, where employees were hired from, things like that. So this is type of evidence that could be relevant if the theory of harm is a labor theory of harm. So so those two things are separate, but essentially we have guidance documents that explain the theory of antitrust for labor markets, and labor data specification to think about the types of data that are needed to do our investigation. And finally, and this is also really important, so in the US we have this HSR. It stands for Hart-Scott-Rodino, which is a law. And so there is this notice requirement. So when two companies seek to merge, if the merger is big enough, they have to file with the antitrust authority to say that they want to merge, and they cannot merge until we clear. And so this involves a bunch of paperwork that the companies have to put with us. And now in this new, and this is in common with the FTC, which is the other, antitrust enforcer in the US. We have the FTC and the DOJ. So we have those together. And in the new proposed forms, now companies have to report on labor markets. So for example, they have to report the 5 largest classification of workers. So this is in terms of occupation. So what are the 5 most common types of workers that you have? Whatever, it could be nurses, doctors, whatever the case may be. So we use a standardized occupational classification, and you have to report how many workers in each of those top 5 categories you have. And then, so that's one of the requirements. And then we also ask the companies to report on their history of unfair labor practices, for example. And so this requirement is in order to help us establish potential monopsony power. Because, for example, if the firms were involved in things like not paying the minimum wage to workers who are due the minimum wage, it's a way, of course, to reduce wages, below legal minimums, but also a way potentially to exercise monopsony power. So that helps us, potentially, as in a holistic sense, together with everything else, it can help us establish firms' market power. And so the firms then are required under this proposed, and again, this is in process, they are not yet, binding. In these new forms, the firms are required to report basic labor market data that is similar to what they were required to report by industry, etc., the sales they make for products. So that's, the way that we have set up institutionally to be able to have the tools, before in all those interventions before, people talked about the tools and Conferencia having the tools to do its work. So similarly, in order to investigate labor cases, we need to arm ourselves with the necessary tools to enforce in labor cases. And this is part of our effort, internal effort, to equip ourselves with those tools. Additionally, we've also been working on relationships with actors outside of the DOJ. So in particular, we've filed a number of amicus briefs on non-competition agreements, for example, and I told you about an earlier one on this franchise no poach. And we also have, so talk about the whole of government approach to competition policy. We have agreements, a memorandum of understanding with other agencies for labor. So this includes the Department of Labor and National Labor Relations Board. So the Department of Labor, they enforce against wage violations. So when people don't get paid the minimum wage, don't get paid overtime when they should, etc., they have the data. So we can, ask them, and they can also teach us actually about the conditions in the industry more generally. What are the, conditions in this industry? Do we hear about this industry engaging in that sort of conduct? And then for the National Labor Relations Board, this is about unionization efforts. So the National Labor Relations Board oversees union elections, and firms can engage in so-called unfair labor practices. This is when they try to squash unions using, illegal methods. And so that, we can learn about as well. And this is another, collaboration that we have at the department. And I'm going to, before I conclude, I realized I wanted to tell you a little bit about these things with the Mexican case. So I learned that in Mexico, there's been a case in soccer that was concerning wage fixing and market allocation. Wage fixing for women, market allocation for men. So this would fall into these categories here of wage fixing and no poach. So one interesting thing about this is that I thought the wage fixing case was quite interesting because it involved not a literal wage fixing as in we pay exactly this, but there was a cap on pay for the soccer players. And the reason why I found this really interesting is because we had a case in the US that was settled called Overwatch League. So this was a case where this was an esports league. So it's an online game playing, but this is so popular. People watch the players play these online games, and sometimes they get live and, they all sit and they, play video games like shooters, all sorts of things. So anyway, one of them is called Overwatch, and it's a big deal, and they have big teams, sponsorships, etc. And the teams are owned by independent entities. Therefore, they compete for players, in the market to hire, the best players to play in those teams. And so what these teams did together with Activision, which is the owner of the game, is that they put in place a so-called, they called it competitive balance tax. So what this was is that there was a maximum amount that each team was allowed to play all players. So this was not an individual wage, but it was capping the total wage bill. So that meant the team couldn't spend more than a certain amount. And if you exceed that cap, then it would be taxed, and that excess would be redistributed equally among all the teams. So essentially all your money, most of your money would go to the other teams. And of course, guess what? This provides a strong incentive for teams not to exceed the cap, since they're taxed almost 100% on anything that's above the cap. And so we argued that this is a case of wage fixing, and we settled. And this was in the settlement we say you cannot impose any rule with an equivalent result. So clearly this is a thing that could happen in those sorts of situations. I thought it's interesting because it's also sports. And so I will also add another thing that we point out to is that in other sports in the US, players are unionized, and sometimes they agree on certain rules about pay. But that's different because it falls under collective bargaining. So they can agree on pay, but those players that I was telling you about in the Overwatch League, they are not unionized. So it doesn't fall under, well, but we negotiated this. So this was just we argued a wage fixing case. If the players are unionized, now it can fall under collective bargaining agreements. So that's different. So, let's not get confused. It really depends. And I think it just shows you how important it is to understand the details of that particular market. What is going on with the workers in that market? It's really important to understand how competition works and what are the institutions in the market at hand. So I just wanted to say that, it sounds like Mexico has been investigating related issues, and this is something that we have a whole string of cases on no poaching agreements that we're continuing to pursue. So let me get back to the conclusion. So then to conclude, principles and tools that are used to analyze the product market competition can be used just as well to analyze labor market competition. In 2022, with the US, the DOJ, we successfully blocked a publisher merger, as I explained, between Penguin Random House and Simon & Schuster. And this was the first merger that was ever blocked due to a labor monopsony concern in the US. And then in 2022 as well, we, for the first time, obtained a guilty plea in a criminal case concerning wage fixing and market allocation. And I will add, as I was telling you, we have multiple criminal cases that were in process, and they passed the motion to dismiss in the sense that judges agreed that wage fixing and no poach are actually per se violations of antitrust laws. But because it's criminal, juries ended up acquitting. In other cases, juries acquitted the people. They didn't think the evidence was strong enough, because this was a jury trial. And finally, we have the 2023 draft merger guidelines. They develop and clarify the analysis of labor markets as part of our merger enforcement. Thank you.
Thank you so much. We have a lot of questions, so I'm going to let our speaker select 3 questions so that we can finish on time, if that's okay. Thank you so much.
All right. So I see here a question about how do you explain that the US recognizes the power of unions? So this is because we are enforcing the law, and it's very interesting historically, because early on, when the Sherman Act was passed, it was used against unions to say, the unions are colluding, etc. So because of that, there was a subsequent law that essentially authorized unions to do their job, and this is a part of the legislation that we have, and we have to follow the law. So, I think we've had a bunch of discussions about what the law is. So they are allowed as part of the so-called labor exemption. So if it's a legitimate union organizing activity, they're allowed to do so because that's, that's the law of the land, and we comply with the law. And then, let's see. I see here a question about cases where workers are hired to obtain information on the commercial strategies of a competitor, and whether this could be considered as an exchange of information. So I think the way to think about this really strongly makes me think about the debate on non-compete clause in the US. And so let me explain a little. I think it's helpful because we have empirical evidence. So a non-competition clause, it's fairly common in the US. It's a contract between the employer and the employee that usually says that the employee is not allowed to work at a competitor or to start their own business in a certain period of time after they leave the employer. And so as a general matter, this is a restraint of trade, note, but the question is it an excessive restraint of trade? And usually the way one first line of approach is to judge the scope and duration of this restriction. So, if I said in the extreme, you cannot work for any company forever, that is the most, we cannot allow this. This is a, unreasonable restraint of trade. So this is, how you might analyze it in terms of whether it's reasonable. And then one of the considerations about whether it's reasonable could be the sharing of trade secrets. So is it reasonable to think that this employee might share important, commercial secrets, and is this non-compete, the least restrictive alternative? That's another important consideration generally in antitrust law, but it applies here, which is maybe there is an interest of the firm that makes sense, but is this blanket prohibition on working to any competitor the least restrictive way of protecting the firm's legitimate business interests? For example, might they be able to instead use a non-disclosure agreement or some other solution that would protect the information that the firm is seeking to protect? And so it's really interesting because in the US with this non-compete, the FTC, so the Federal Trade Commission, they proposed a rule that would essentially ban these non-competes in almost all cases. So with very few exceptions, it just wouldn't be allowed. Note that in the US, some states already ban non-competes. One of the famous ones is California, where they are not actually banned. You can write them down, but they're non-enforceable. If you go to the judge, it just doesn't bind in California. So some states already implemented that, but now the FTC is proposing that we just ban them outright for the whole country. And it's interesting because in their proposed rulemaking, the FTC goes through very detailed analysis of the economics literature on the impact of these non-competes. And so we're able to look at the impact because I told you different US states banned non-competes, and sometimes only for certain types of workers. Sometimes it's for workers who make less than a certain amount, with the reasoning being how important can their secret information be if they are low-paid worker. So, and this is very good for us researchers because then we can look at the effects on the workers who are newly liberated from these non-competition clauses versus other workers who are perhaps still covered. And the general result of this is that, as expected, these non-competes reduce worker mobility, but that's not too surprising because that's sort of the goal. And they also, in most cases, tend to reduce wages for workers. So, that sort of points to the fact that they might have an anti-competitive effect. Of course, it's important to, certainly in economics, we want to think about also the broader effects on the market. And there is one really interesting paper that's just been accepted in one of our top journals called Econometrica by Xi, where she looks at the market for CEOs and top executives. So that's a very special case. But interestingly, the result of that paper is that on average, the CEOs are adequately, if they have a non-compete that's very restrictive, they tend to be paid more. So from the point of view of the CEOs, it turns out in her analysis, they are not harmed, right? They probably have enough knowledge to be able to negotiate. But who are harmed? The other companies who are trying to hire the CEOs. So they were able to show that the harm to the other companies exceeded the benefit, of the ability to make that contract. So it's also interesting that it's this type of restriction of trade not only can harm workers, but in some cases can harm competition in the market more broadly, because others who are wanting to, especially, you could think about a startup, a new company trying to hire an experienced, CEO to help them grow. Now these non-competition agreements prevent them from doing so. So it's an important consideration to think about that. It's not just, of course, it's important from the worker side, but you also have to think about the effects on competition among firms in the market. So thanks for raising that issue. Let's see. And then, so I have a question here about the merger guidelines and concentration in general. And, I want to speak to the issue that concentration has always been a tool that we use for screening. The HHI has always been part of the toolbox, and we're continuing to use it. And, and that includes the labor market. And so, there is evidence out there in the literature in economics that mergers that tend to lead to highly concentrated markets are more likely to increase prices. And similarly, I think I told you there's 2 papers since, I've been looking at labor markets. One paper is looking at hospital mergers specifically, and they find that the wages of workers, especially those specialized workers who essentially can have few employment opportunities outside of hospitals. So, if you're a cleaner, you might be able to work somewhere else, but if you're the pharmacist at the hospital, your opportunities are limited to a specialized set of employers. So that paper was published in American Economic Review and shows that the increase in concentration predicts wage suppression for the specialized workers in hospitals. And so that's a paper by Prager and Schmidt. And then there's another paper by Arnold that does a similar analysis, but looking at all industries in the US. And he finds the same result, namely that a merger that greatly increases labor market concentration leads to decreases in wages for workers. Why am I pointing to this is because concentration, therefore, is a useful screening tool, in terms of predicting the likely effect of mergers. And we have to remember that antitrust is very much a risk assessment exercise. We're asking whether the merger may substantially reduce competition. We don't have a crystal ball. We cannot be sure of what's going to happen exactly. So we're trying to assess risk. And so based on, for example, these academic papers, of course, that's not enough. We'll still have to do an investigation. But, we think that concentration, including for labor markets, continues to be a valid screening tool to do this risk assessment exercise. And let's see. Right, so somebody is asking me about the buyer's bargaining power for Medicare. And so, frankly, this is, in some cases, I think I'm going to use the case of unions because that's really the one that I'm immediately thinking of. For policy reasons, the politicians, not us, the antitrust authorities, might decide that it's fine to let some actors form a buyer or seller cartel of sorts. So that's what unions are in a sense. But we decided that for policy reasons, we're going to allow that. So, depending on circumstances, policy priorities, you could hypothetically have that, but it's not to the antitrust authorities to do this. It's if the law provides an exemption, and I think some talked about exemptions in some sectors, etc. That's one thing, but it's not the job of the antitrust authority. We enforce competition. If the law says that some actors are allowed, that's fine, they're allowed by law, but our job is to enforce competition. So, all right, and then there's a very interesting question about whether monopsony or monopoly is more harmful to the economy. And I think, it's a little bit hard to tell. I think the economic evidence is in progress, and it's a little hard to disentangle because often they are related and they kind of go together, like hospitals being a case in point. Hospitals tend to be local product market, but they're also local labor market. So there is a stew of both things going on, and that's not for every industry, but in many cases they kind of go together, and trying to disentangle the effect of the one or the other is a non-trivial endeavor in terms of trying to find out what's going on there. One interesting paper I've seen, this is a working paper, so it's not published yet, but They look at the impact of DOJ past enforcement in conduct cases, so not mergers, but conduct cases, and how it impacted the local industry where enforcement was done by the DOJ. And interestingly, they found that there was a significant increase in employment. That, so basically, the point is that output and labor markets are linked. So if we are enforcing against companies who perhaps are having an anti-competitive conduct in the product market, that will liberate competition, which means more production. That can lead to more workers being hired as well, potentially also benefiting workers. So that's just an example of how it can go both ways, and it's not obvious to try to quantify, which one is it. I'm sure if you make a bunch of assumptions, etc., you could get there, but broadly, it seems it's not easy to disentangle it, by doing a study. And the last thing I want to say is that in antitrust enforcement, we until recently, there was essentially zero enforcement in labor markets. So, I would also make an argument in terms of relative, where we can put some more force. If you start from zero enforcement and you do your job well, you can probably find some very helpful enforcement actions, when you're doing very little. So we already do a bunch in the product market. The labor market is a huge market. It's a very important market for people's lives. And when we start from nothing, we're probably able to provide significant competition benefits by starting a program of enforcement to improve competitive conditions in the labor market. All right, I think I broadly covered. Thank you so much.
Agradecemos la participación de Ioana Marinescu y entregamos un pequeño detalle en reconocimiento. Muchas gracias.